Today is an introduction to lawsuits and how they work. We'll begin by talking a little bit about the structure of the court system and how the court system operates. We'll talk a little bit about the structure of a lawsuit and how a lawsuit proceeds. And then we will talk a little bit more topic specific about patent infringement or copyright infringement lawsuits. And we'll take a look at a specific example of how those lawsuits proceed throughout the court system. Again, today is going to be a little bit of a more academic discussion about how the law operates. We're not going to talk a lot about AFs and DAs and counterplans. And the goal is to provide you with a vocabulary through which to start to proceed with reading law review articles and reading legal scholarship. So with that in mind, if I use a legal term that I have not defined in the lecture, just raise your hand and ask me to define it, because my goal here for you today is to help you kind of understand and demystify some of the legal language that you undoubtedly are encountering as you go about your research on the IP topic. So, how does the court system work? What is its structure? The United States has a federal system of government, which creates two distinct but connected in some ways systems of courts. The federal courts and the state courts. Okay? So, where do we start? We start at the trial court level. In the state court system, these are state trial courts. In the federal system, we call these district courts. And the trial court is where most of the action happens, okay? This is where trials occur. This is where the lawsuit is tried. This is where all pretrial motions happen. This is where discovery disputes get litigated. This is where the action happens, at the trial court. So, what happens if I lose at the trial court level? What do I do? I've lost what do I do? Yeah, appeal. I appeal. Okay. I want to appeal. Where do I appeal to? In the state court system, I appeal to state appellate courts. In the federal court system, I appeal to circuit courts of appeal. The federal circuit court system is divided into 13 different circuit courts of appeal, 12 of which are regionally divided. In New Hampshire, we are in the First Circuit Court of Appeal. If you go over the river to Vermont, you are in the Second Circuit Court of Appeal. And there's one special Court of Appeal which only hears particular kinds of cases, and it is relevant to our efforts because it hears patent cases. So the Federal Circuit Court of Appeal has jurisdiction over all patent cases, and we'll talk about that a little bit more later on. So, I lost at the trial court. I lost at the Court of Appeal. What do I do? Yeah, I got to appeal again, and I need to appeal to a Supreme Court. So in the state court system, I start by going to the state Supreme Courts. In the federal court system, I don't have that option. I need to go to the Supreme Court of the United States. Now, the Supreme Court of the United States can also hear appeals from state Supreme Courts. So, the state court system meets the federal court system at the Supreme Court of the United States. Does this make sense to everybody? Good. So, we've introduced this lecture is about civil procedure. What do we mean by civil? Well, civil is in opposition to criminal. There are two kinds of cases that courts hear, criminal and civil. A criminal case, this is like what you see on Law and Order, right? This is where someone commits a crime and the government then prosecutes them for that crime and potentially puts them in jail or fines them, puts them on probation, right? Those are the remedies for a crime. In a civil action, we are talking about violations of private rights, okay? So my rights have been violated in some way, shape, or form. With criminal law, we're talking about violations of public rights, typically. So my rights have been violated, and I would like to seek a remedy. There are two civil remedies that are useful to know. First, this is the most common, money damages. I have been wronged. I want money. You have infringed on my patent. I should get paid for that to restore the financial position that I would have been in had you not infringed on my patent. The other common civil remedy is called an injunction. Does anyone know what an injunction is? Yeah.
It's like a court-issued mandate to tell you to stop doing something.
Exactly. Stop doing that. The court says, stop selling the item that is infringing on my patent. So an injunction is a court order that tells a party to stop doing something. So two major civil remedies, money damages, injunctions. There are some actions, some encounters that can have both criminal and civil implications. For example, I'm having an argument with Turner about who won the cities of the ADT on the healthcare topic. Turner gets tired of it. He punches me in the face. That has criminal liability associated with it. That is assault and battery. The state of New Hampshire could prosecute Turner for that crime, for punching me in the face. Additionally, I may have civil remedies. I may be able to sue Turner for the damage that's done to my face and have him pay for my facial reconstruction surgery. Yeah, it's a serious fight. So, some actions can have both criminal and civil consequences, but civil consequences occur in civil lawsuits. Criminal consequences happen in criminal proceedings. So, they're different systems. So, just like debate, the civil law is an adversarial system, meaning there are two sides and they are arguing against one another. Instead of affirmative versus negative, in these cases we have plaintiff versus defendant. Okay? The plaintiff is the party who brings the lawsuit. Okay? They are the person who says, I was wronged, and because I was wronged, I should get money, or I should get a court order that tells the defendant to stop doing the wrong thing. I should get an injunction. Okay? Who can be a plaintiff? Plaintiffs need to have standing. Standing is the right or the legal capacity to be a plaintiff in a particular action or lawsuit. There are typically three major requirements for a plaintiff to have standing in a lawsuit. The first requirement is that there is an injury. There is a concrete injury that has been suffered by the plaintiff. Okay? I have been punched in the face. I have suffered an injury. That injury needs to be traceable Okay, to the other side of this lawsuit, the defendant, Turner punched me in the face, traceable. It needs to be redressable by the courts, meaning the remedy needs to solve the problem, solve the injury, right? So I had to have facial reconstruction surgery, and if I get money, maybe I can pay for that. Does that make sense? So in a civil lawsuit, typically we have always a judge. What's the role of the judge? This is an existential question that we always ask ourselves. In the law, there are easier answers to this. The judge always decides what the law is. The jury decides what the facts are. So there's a clear division of labor. Judges decide law, juries decide facts. It's worth noting that in some lawsuits, the right to a jury trial is waived and the judge acts as the decider of fact. So the judge can sometimes be the decider of fact. The jury can never be a decider of law. That is always the realm of the judge. So, how do judges go about figuring out or knowing what the law is? So, we start off with the general principle that we have a common law tradition within the United States. I know BK talked about this a little bit. Can anyone define what the common law is, or the idea of the common law? Yeah.
It kind of traces back to like England.
Yeah.
This idea of the things that kind of like within law are agreed upon, and we can go back to and make decisions based off of those things or those principles.
Absolutely. So the common law is the idea that prior cases can serve as precedent, and we can go back to prior cases to understand what the law is and what the law should be going forward. One principle under the common law that you'll commonly see within the literature is this idea of stare decisis.
Bless you.
And stare decisis means stand by your decision. It means that future courts should take prior precedent as serious and as something to be abided by. An important thing to understand about precedent, about stare decisis, and about the common law is that rulings are only binding on lower courts within the same system. Okay? So, who is bound by rulings of the Supreme Court? Everybody. Who is bound by rulings of a Federal Circuit Court of Appeal? The district courts within that circuit. Okay, so it gets narrower and narrower. The state appeals courts are not necessarily bound by decisions of Federal Circuit Courts of Appeals. They're in different court systems. Okay, so priority and authority is given within the system. And this is what makes the Supreme Court such an important entity, is because whatever their rule is, that has to be abided by every court regardless of court system, the federal system or the state system. One thing to note here is that federal courts have limited jurisdiction. Federal courts cannot hear every single case. They can only hear cases that are either questions of federal law or disputes that are between people who live in different states who are having a really important fight, or a fight with a lot of money at stake. State courts can typically hear just about any case. Now, there are some exceptions to this, so like the state courts can't decide what the Constitution says, of course, but by and large, most any case can originate in a state trial court level. So when we're thinking about what the law is and how judges decide what the law is and how lawyers argue what the law is, they look to the authority of different legal sources. So there's a general sort of hierarchy here, and it begins with a general principle. And this principle is that when we're talking about legal sources, federal law is supreme over state law. So in the Constitution, there's this thing called the Supremacy Clause, right? It says that the U.S. Constitution is the law, the supreme law of the land, and federal law is supreme over state laws. So sources of federal law are more important than and override contradicting state law sources. So what is the sort of above all source of law in the United States? The Constitution, absolutely. We start with the federal Constitution. And then we have federal statutes. Statutes are bills passed by Congress, signed by the president through the constitutional process. So federal statutes are next in this hierarchy. Then federal regulations, rules made by agencies. And then federal cases. So this is an important thing to note. Laws that are passed by Congress supersede federal cases and federal rulings that contradict them. So you look first to, are there any statutes that speak to the issue? Copyright and patent law is largely, not entirely, but largely statutory. There are core statutes that govern how these areas of law develop. The Copyright Act, the Patent Act. These are long-standing sources of statutory law that govern intellectual property. So one thing to keep in mind when you're reading these cases is that statutory law is of particular import in IP. All right, what's next? Most states have constitutions of their own. State constitutions. State statutes. State regulations. State cases. That is the general hierarchy of sources of law that judges look at, okay, when they are determining what the law is and who should win any individual lawsuit. Okay? Does that all make sense? Any questions about that part? All right. So the next thing that we're going to talk about is we are going to walk through a landmark case in the area of intellectual property law as a learning tool to understand how this process works and how a particular court case moves about the system. So Apple versus Samsung is one of the most prominent intellectual property cases of all time. Apple, in the mid-2000s, filed a series of patents about what? The iPhone. And the patents cover basically all parts of the design of the iPhone. Its shape, how the button looks, the Zoom features, right? All sorts of stuff is covered by these patents that Apple filed. Apple believed that Samsung had copied their patents, unfairly infringing on them, selling phones that undermine Apple's market share. Apple was mad. So what did they do about it? They sued. They filed a lawsuit. They said, you have infringed upon my patent. I am upset about that. I am suing you. Where? Yeah. Are we in federal court or state court? I don't think we have consensus on that. We're in federal court. It's a district court. Yeah. This is federal court in the Northern District of California. And Apple is suing Samsung for patent infringement. A few things to note about this here. One, this language of counterclaim. Okay, so in any lawsuit, Apple sues Samsung, Coke sues Pepsi, what have you. The other side has an opportunity to say, hey, I was wrong in this dispute too. You did this other thing that harmed me. That's a counterclaim. So in the counterclaim, Samsung is the plaintiff, Apple is the defendant. So, we'll kind of run through a timeline because this case is a little bit complicated. And now, mind you, Apple versus Samsung is actually multiple lawsuits. So there are 2 lawsuits. The complaint that you have here is the second lawsuit. So this is Apple 2, but I'm going to try to walk through what happened with Apple 1 because I think that it is a more interesting process. It goes all the way to the Supreme Court, and it develops in a really interesting way. Okay, so we know that Apple has their patents, and in 2011, Apple files a complaint. The complaint is the initial pleading in the lawsuit. So this is a formal document that says, hey Samsung, I am suing you, and here's why I am suing you. And this is what a complaint looks like, okay? So you have the caption, Apple versus Samsung. You have a short and plain statement of the facts of the case and the legal dispute at order, right? Samsung has systematically copied Apple's innovative technology and products and deluged markets with infringing devices in an effort to usurp market share from Apple. That's what we're mad about. That's why we're suing. Who are parties? Where do they live? And then why are we in this court? Okay. This court has subject matter jurisdiction. What is that word? So remember, this is federal courts can only hear certain kinds of cases. Certain kinds of cases. Subject matter jurisdiction refers to the particular kinds of cases that can be heard by particular courts. Here, Apple says that the federal courts can hear this kind of case because it is a question of federal law. And that's true. It is a question of federal law. So, not a big deal there. This court has personal jurisdiction. What does that mean? Personal jurisdiction, yes?
Is that because it's not the specific court that the case should go to, like...
Okay, so, so that's good. That actually is venue. Which court do we go to in a particular area? Personal jurisdiction is, does the court have power over the particular defendant? Okay? So, can I sue you in this court? And so, Apple says, well, I can sue Samsung in California because Samsung sells their infringing, usurping phones in the state of California. They've committed the wrongful act in the state of California. That's why I can submit this to a federal court within California. Personal jurisdiction is always about the state that the federal court sits in. Now, why, oh why, are we really in California? Why does Apple want to be in California?
Because it's incorporated there.
Yeah, Apple lives in California. They just told us they do. Apple is a California corporation with its principal place of business at this address in Cupertino, California. Samsung does not live in California. Samsung lives in South Korea. Okay? So Apple says, we kind of want the home field advantage. We want to be in California. So that's why we're going to try to file this lawsuit in California. And then they say, venue, we should be in this particular district court because, once again, this is where Samsung is selling their harmful phones. But really, this is where we live. That's why we're filing this lawsuit here. An interesting little kind of part of this. So also in 2011, what happens? Samsung has been sued. What do? What's the next step in the process? Samsung is going to file an answer. And an answer is exactly what it sounds like. You take the arguments that are in this complaint and you say, you are wrong. And I would like for people to take a wild guess at what order Samsung answers Apple's arguments. In the order that they were made. Maybe line by line. Okay? Important. It's a portable skill. So Samsung answered Apple's arguments in the order that they were made, and then they also made these counterclaims. They actually said, oh, well, you wronged us in this way and did this and that, and we want to sue you too. We're upset. Also in 2011, after the answer is filed, we get discovery. Discovery is a long and arduous process where both sides share documents about each other and learn more about the dispute at hand. Sometimes discovery can take years and years and years and years and years. This process actually took pretty quickly because in 2012, we had a jury trial. So a jury was impaneled. Apple made their arguments. Samsung made their arguments. A jury deliberated, and they said, Apple wins. They said, yes, Samsung did infringe upon Apple's patents. They sold patent-infringing phones that usurped Apple's market share, and as a result, Samsung needs to pay Apple $1 billion. The initial jury award is $1 billion. That is a lot of money. What happens next? Okay, also in the jury award, forgot to mention this, the jury said Samsung's counterclaims, wrong, hated that, not real. So they zeroed the counterclaims in the jury award. So what happens next is Samsung says, whoa, 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 that is too much. We would like for the judge to step in and do what we in legal circles call a JNOV. What is a JNOV? A JNOV is a judgment notwithstanding the verdict. Judgment notwithstanding the verdict. This is where the judge steps in and says, jury, what you did was illegal. Okay? What you did was illegal. And we will give a judgment notwithstanding the verdict. So, remember, we've got a bifurcation of who decides law and who decides facts. So, the judge cannot say, jury, you were wrong about the facts. They can only say, you were wrong about the law. Yes?
Could you give a few examples of this sort of thing happening? I know nothing.
As a matter of course, judgment notwithstanding the verdict rarely, if ever, happens. It is a procedural prerequisite to appeal. So you're trying to get the judge on the record to make some appeals. What happens in this case, and what can happen in some other cases, is this JNOV process can be basically a way of getting the damages reduced. So you're not reversing this finding that you've infringed, but it can be a way that you start to reduce the amount of damages that you are owed. Okay? Apple also wants something. Like, okay, they're going to get $1 billion, and that's cool and all, but they want something else, right? What else does Apple want?
Injunction.
They want an injunction. Stop selling the phones. All right. Now, mind you, we're still at the trial court. A lot has happened, and we're still sitting at the district court level. So, Samsung has asked the judge to throw away the jury's verdict or to reduce some of the damages. Apple has asked the judge to grant an injunction. And in this particular interaction, Samsung wins. Kind of. So the judge doesn't throw out the whole verdict. He says there should be a new trial on damages. So, says, look, we're not going to get rid of this idea that Samsung has infringed on Apple's patents, because they have, and the jury's decided that they have. But $1 billion is too much. We're going to have a new trial about how much damages are owed Apple as a result of that infringement. And then said, Apple, I will not give you your injunction. So who's happy with this result? Yeah, a little bit. Like, they're still going to have to, probably pay a bunch of money at some point in the process. But Apple is largely unhappy for this. So when you're unhappy with the ruling, well, what do? You appeal. Okay, finally we get to appeal. So our injunction has been denied. We are going to appeal the denial of our injunction. Where do we appeal? Which circuit court, though? The circuit court above the district court. So we're in the Northern District of California. We've lost our injunction, and we're going to appeal to the Ninth Circuit Court of Appeals about this injunction problem because we're not very happy about this. In the Ninth Circuit, Apple wins. They get their injunction. Deep breath. We've won. We've got our injunction. But we still need to do a retrial about how much damages we actually owe Samsung. So what do? 2013. Damages retrial. After retrying the damages, Samsung needs to pay Apple $290 million. Whew, that is still a lot of money. I don't have $290 million. And Samsung was also not particularly happy about this. So what did Samsung do? They appealed. Absolutely. Where did they appeal? So we heard the injunction appeal in the Ninth Circuit Court of Appeal because the Ninth Circuit is the circuit court that sits above the district court in the Northern District of California. However, the appeal from the damages retrial was heard by the Federal Circuit Court of Appeals. Why? And the reason is actually quite simple and quite useful for us. The Federal Circuit Court of Appeals is the appeals court for issues involving patent law. That's simple, that's why. This injunction appeal was not about patent law, it was about the injunction. Yeah.
Is there a reason Samsung didn't have to file another JNOV before their appeal in this instance?
They probably did, and lost, and it gets denied. And again, it happens sort of as a matter of course. The JNOV mattered at this stage because the judge ruled in their favor, right? Said, yeah, we should get a new trial. All right. So they appeal to the Federal Circuit, 2015. The Federal Circuit Courts of Appeal hears the appeal of this damages retrial, and Apple wins. All right, another dub for Apple.
Wait, that's separate from the initial $200 million, $290 million?
No, this is the 200. This is the appeal of that. This is the appeal of the 290 million.
Oh, I thought the $290 million occurred in the Federal Circuit Court of Appeals.
That's at the retrial happens in the district court.
Okay.
So the retrial happened in the district court. Apple is awarded $290 million. Samsung appealed to the Federal Circuit Court of Appeals, who affirmed. They said, yes, that is a proper verdict. Samsung, in fact, owes Apple $290 million. All right. You're Samsung. What do? Appeal again. Where do we appeal? The Supreme Court. 2016. Samsung appeals to SCOTUS. What happens in this case? Samsung wins. Okay, so Samsung wins at the Supreme Court. The Supreme Court in an 8-0 decision says that the way that this damages trial happened was all wrong. They did it all wrong. So what happens?
All of those things get done back.
It gets remanded, is the word. So remand, meaning it gets issued back down to the trial court, the district court, for what? New damages trial.
Wait, what was wrong about the way that the court proceeded?
So the question in the Supreme Court case was about the Patent Act uses this phrase. So one thing to know about legal disputes is they're topicality debates. They're about what do words mean, how do we define and interpret words. So the Patent Act uses a phrase, article of manufacture, when it talks about how damages should be calculated. It says you should take each article of manufacture and you should calculate how much damage it caused to the original patent holder. And the Supreme Court, and again, this is like a bit of a technical decision, the Supreme Court says that the way that the Federal Circuit Court of Appeals viewed this issue of article of manufacture, they had the wrong interpretation of the word. So we should have a different interpretation of that word in the Patent Act, and we need to have a new trial that is about that interpretation. Okay? So, what do we do now? Well, we had our new trial, right? New trial in district court. We filed our lawsuit 5 years ago. It is now, we're going to fast forward a couple years. We're in 2018. The Supreme Court has said, we screwed up the way that we calculated damages, and this damages retrial, which awarded Apple $290 million. This is one of my favorite parts of this whole saga. So the retrial for damages awards Apple $539 million. Wow. So Apple loses in the Supreme Court. We do a retrial and they get more money. How in God's name does that happen when clearly the direction of the Supreme Court was Apple got too much money? This story comes to an end a couple months later in June of 2018. Apple and Samsung settle for an undisclosed amount of money. 7 years later,
This is like beef.
2 retrials, appeals about injunctions, appeals to the Supreme Court, remand back to the district court, all to settle. And that's how the law works. Yeah,
I have 2 questions.
of course.
Samsung agree to stop selling phones that highlight specific things in Apple patents?
They were ordered to, after the injunction was granted by the Ninth Circuit Court of Appeals in 2012.
Oh, that is okay.
Yeah. That was finished and done. So there was an injunction filed. Apple got their injunction. Yeah.
Why did Samsung deal that?
The reason is it is very hard and very rare to get the Supreme Court to review something. So the Supreme Court gets many thousands of petitions from the circuit courts of appeal every year, and they take a few hundred of them. So a like infinitesimally small percentage of cases actually end up getting taken by the Supreme Court. This case is unique because we do have a Supreme Court decision, and one that was unanimous. So like there was no dissent. All the judges agreed that the damages retrial was done incorrectly according to the Patent Act. But the retrial then said, no, actually Apple should get more money. So these are the twists and turns that a patent infringement lawsuit takes. And the takeaway is that there are a lot of steps to this process, and there's a lot of vocabulary involved, and it's not so easy to trace the procedural history. Okay? So what are some things that we can do to find out how a particular lawsuit goes down, or to learn more about this stuff? So, you are lucky to have access to Dartmouth's public resources in the library, right? We talked about this last night, I'm sure. So, you actually have access to the exact same research databases that literal lawyers use. So, there are two competing products for legal research, and Dartmouth has access to both of them. So how do we find them? Here we are. This is the Dartmouth Library webpage. Databases. The first one is LexisNexis, which is when a university pays for it. It's called Nexus Uni. You can click on it right there, Nexus Uni. There's a little bit of a kind of culture war in the legal space about LexisNexis versus Westlaw, and I'm a Westlaw person, so I will show you Westlaw. Dartmouth has access to full Westlaw, Westlaw Next. Pretty cool. So, how do we learn about this? We want to find Apple versus Samsung. All right. So I get shown two cases in the Federal Circuit Courts of Appeals. So this is the one that upheld the damages trial. This is this one. Yeah. I think this one is about Apple too. Okay. We see Westlaw also shows us the important statutes. So here is the Patent Act, and we get a sense of what rules are important there. We get some regulations about patentability. And then this is where the money is made for you all, because this is where cards live. Secondary sources. This is where you will find law review articles about important cases. So this is Goliath versus Goliath fallout, the repercussions of Apple versus Samsung. Okay, so if you wanted to read more about this litigation, how it proceeded, if you want to learn about the Apple II lawsuits, if you want to learn about the lawsuits that Samsung filed against Apple in front of the WTO and in South Korea, you can learn about them in that law review. But one thing to note, when was this law review article written? It was over here. we had a Supreme Court case to go. So you know, keep dates in mind. I like to date search for secondary sources. But how do I view this as a case, and how do I figure out what's going on? Okay, so I like to start with the highest level of authority that we can find. So I know that Apple versus Samsung went to the Supreme Court. So I go down here to jurisdiction. We're all looking at cases in federal court, but I want Supreme Court. There we are. If you have a synopsis, that means you've got a case there. So, this is the decision. This is where I went to read the Supreme Court decision of Samsung versus Apple is how it was titled, because Samsung was the appellant at this point. And so we see that the decision was written by Justice Sonia Sotomayor. And again, article of manufacturer is the issue involved here. Reversed and remanded, meaning the decision of the Circuit Court of Appeal is reversed and we send it back to the trial court to understand the case. All right. Well, if I'm trying to understand how this lawsuit developed, I can click on history. And you'll see that it's a very, very complicated web that Westlaw will read, which traces back, so you need to zoom in on it a little bit, but it starts at a very granular level. So these are the patent filings in front of the PTO, okay? Then you have trial court, appellate court, Supreme Court. So Westlaw will show you how a case develops if you hit on the history section. Now, another place that I think will have some utility for you, because this again is where you're going to find some cards, citing references. These are any case or any secondary source that has cited the Apple versus Samsung Supreme Court case. So for our purposes, we want secondary sources. And we want law reviews. So, design patents, common and costly mistakes. Supreme Court's focus on intellectual property damages. Remedies, equity, and the Juris Doctor. Fun stuff. So if we're looking for places where we might find some cards, we might look for the secondary sources that are cited by these major cases. If I'm looking for secondary sources in and of themselves, okay, I can go here and I can look by type for law reviews and journals. And then I can search for sui generis intellectual property. Nice. And then I always like to date check anytime I'm searching for cards, because I'm looking for recent cards. Westlaw has this last 3 years function. All right, sui generis cards, last 3 years. Okay, interesting. Maybe I've got some cards that I'll cut from my generic group. Any questions about this stuff? Legal research? All right, the other thing to keep in mind, some of this stuff can be a little bit confusing and you will inevitably stumble upon some words that you are unfamiliar with when you start to read cases and you start to read law review articles. This is true of anyone who tries to do this process, including people who are in law school. Sometimes professors have this happen to them as well. And so my advice is to look up that word and just take it slow, right? Don't fake it till you make it. Learn what these words mean. Try to understand what these words mean. Ask questions about them. Ask your lab leaders. Ask me if you want to. But take it slow, and you'll do just fine in terms of legal research. And with that, go to generics.